So the Supreme Court will once again review whether or not they want to protect the ATF's unconstitutional rule against 80%ers.
Which is going forward, the manufacturers are not going to be able to sell you what was at that point known as an 80% receiver.
Bump stocks, arm braces, 80% receivers, and now they're claiming force reset triggers or machine guns.
This is a pistol brace. I know it's scary.
Only specifically to its protections of customers, and really that was because the ATF had promised that they would not enforce the rule against customers.
Supreme Court's emergency order. The Supreme Court finds itself once again at the epicenter of a crucial Second Amendment debate as it deliberates on the ATF's controversial rule regarding 80% lower receivers. This development comes in the wake of a recent limited injunction secured by companies like Defense Distributed and 80% Arms in Texas, which safeguarded their interests and those of their customers. However, the ATF has petitioned the Supreme Court to nullify this injunction, asserting that it contravenes a prior emergency stay order. The crux of the matter lies in Judge O'Connor's original finding that the ATF's rule on receivers was facially invalid under the statutory framework, contending that Congress never conferred the ATF with the authority to regulate these components.
So the Supreme Court will once again review whether or not they want to protect the ATF's unconstitutional rule against 80%ers.
On the ATF's rule on 80% lowers, frames, and receivers.
Because they claim Judge O'Connor is defying the Supreme Court's recent emergency stay order, which they issued in this case.
This initial victory led other industry players, including Black Hawk Manufacturing Group operating as 80% Arms and Defense Distributed, to seek similar protections for their interests. Judge O'Connor ultimately granted these requests, further amplifying the significance of this case. As the legal battle progressed, the plaintiffs pursued a motion for summary judgment seeking a comprehensive annulment of the frames and receivers rule on a national scale. In a monumentous decision, Judge O'Connor granted their motion, resulting in a sweeping nationwide vacatur of the rule. This victory not only reverberated throughout the industry, but also set the stage for a broader reevaluation of the ATF's regulatory authority in this domain. The ATF's plea to the Supreme Court centers on whether Judge O'Connor's limited injunction exceeded his jurisdiction and whether the emergency stay order should take precedence. The dispute encapsulates a broader debate about the proper bounds of the ATF's regulatory power in relation to firearms components. The court's decision in this case could have far-reaching implications for Second Amendment rights, not only for companies directly affected, but for the broader firearms community. In essence, the Supreme Court's engagement with this emergency order underscores the critical role it plays in shaping the contours of arm control regulations. The outcome of this case could redefine the parameters of the ATF's authority, potentially impacting the way in which firearms components are regulated and assessed by law-abiding citizens across the nation. As the legal proceedings unfold, the entire firearms community watches with bated breath, aware that this case holds the potential to shape the future of Second Amendment jurisprudence. ATF's legal battle. The ATF's response to the initial summary judgment, which resulted in a nationwide vacatur of the frames and receivers rule, underscores their determination to defend their position. Unwilling to accept such a substantial loss, the ATF swiftly appealed the decision to the Fifth Circuit. They also sought a stay from both the Fifth Circuit and Judge O'Connor, hoping to halt the enforcement of the summary judgment. However, both requests for a stay were denied. Subsequently, the ATF turned to the Supreme Court, seeking their intervention for the first time in this case. They implored the court to issue a stay on the nationwide vacatur. In a closely divided 5-4 decision, the Supreme Court sided with the ATF, with Justices Barrett and Roberts joining the liberal judges in favor of the ATF's position. This ruling effectively put the nationwide vacatur on hold. Meanwhile, the motion for summary judgment remained under review at the Fifth Circuit level. The outcome of this appeal would hold immense significance for the overall trajectory of the case.
Once again has a chance to stop the ATF's current Second Amendment violations.
Which is going forward, the manufacturers are not going to be able to sell you what was at that point known as an 80% receiver.
The ATF has gone crying up to the Supreme Court once again, asking for them to vacate a limited injunction that was upheld by the Fifth Circuit.
However, in a strategic move, the plaintiffs returned to Judge O'Connor, petitioning for a reinstatement of the limited preliminary injunction. They argued that while the Supreme Court's emergency stay prevented a nationwide vacatur, it didn't preclude Judge O'Connor from reissuing the prior limited injunction, which had protected their company and customers.
Fifth Circuit did is they agreed with Judge O'Connor that he could issue a limited injunction.
There was no rhyme or reason for the 80% number to begin with.
But the ATF is once again crying up to the Supreme Court, asking for the Supreme Court to strike down that ruling.
Judge O'Connor concurred with this argument and granted the injunction, thereby re-establishing protections for the company and its customers. Nevertheless, the ADF, unwilling to concede defeat, promptly filed an appeal to the Fifth Circuit, contending that Judge O'Connor had directly contradicted the Supreme Court's recent emergency order. They argued that Judge O'Connor didn't have the authority to issue such an injunction. Upon review, the Fifth Circuit concurred with Judge O'Connor, affirming his ability to issue a limited injunction. However, they did choose to vacate a portion of the injunction that granted protections to all customers of the companies involved. This decision likely stemmed from a desire to maintain the limited scope of the injunction, potentially to avoid further intervention from the Supreme Court. The ADF's insistence on contesting each development in the case highlights the agency's unwavering commitment to upholding their stance on frames and receivers. Their repeated appeals and attempts to secure stays demonstrate their determination to maintain their position on this issue, even in the face of significant legal challenges. This ongoing legal battle is a testament to the complexity and significance of Second Amendment rights in contemporary legal discourse. Supreme Court's ADF dilemma. The recent developments in the ADF's ongoing legal battle have introduced a new layer of complexity to an already contentious issue. The Fifth Circuit's decision to remove protections for customers while maintaining safeguards for the companies involved reflects a nuanced understanding of legal remedies. They acknowledge the distinction between a vacatur and an injunction relief, aligning with the argument that had been consistently made by the parties involved. However, the ADF's response has been swift and assertive. They've resorted to seeking emergency relief from the Supreme Court once again. Their request centers on the assertion that Judge O'Connor overstepped his authority in issuing the new injunction.
Only specifically to its protections of customers, and really that was because the ATF had promised that they would not enforce the rule against customers.
And what we saw come out of the ATF last year is a final rule on what they call frames and receivers. Now,
which protected the companies like 80% Arms and then also Defense Distributed.
They argue that the prior emergency order issued by the Supreme Court precludes any further relief of this nature. Justice Alito, upon receiving the emergency request, opted to grant a temporary administrative stay on the new injunction. This stay remains in effect until October 16th, providing a brief reprieve for both parties involved. The Supreme Court will then deliberate on whether to uphold a new limited injunction which exclusively protects the companies. The stakes are undeniably high at this juncture. There exists a palpable concern that the Supreme Court might once again align with the ADF, potentially closing the door on any potential relief for the companies involved. This apprehension stems from past inconsistencies in the ADF's positions and decisions, which have engendered a degree of skepticism regarding their promises. The intricacies of this legal battle highlight the intricate dance between different forms of legal remedies and the authority of various courts in interpreting and applying them. The nuances in the Fifth Circuit's decision indicate a keen awareness of the multifaceted nature of legal relief. As the case continues to unfold, it will likely serve as a critical touchstone in discussions surrounding Second Amendment rights and the regulatory authority of agencies like the ADF. The October 16th decision by the Supreme Court will undoubtedly mark a pivotal moment in this protracted legal saga. ADF lawsuit's far-reaching implications. The Vanderstock lawsuit holds immense significance not only for its immediate implications, but also for its potential influence on other ongoing lawsuits against the ADF. One notable case is the lawsuit challenging the ADF's rule on pistol braces, which saw Judge O'Connor granting protection to members of the Firearm Policy Coalition and a specific company, as well as their customers. This decision barred the ADF from enforcing the brace rule against these individuals. However, if the Supreme Court deems the injunction in the Vanderstock lawsuit as improper, it could set a precedent for the ADF to seek similar emergency relief from the court. such a move could potentially halt the positive decisions that have been obtained in cases like the pistol brace lawsuit.
This is a pistol brace. I know it's scary.
The ATF has a history of reinterpreting federal law in an attempt to expand what firearms accessories are illegal.
It is also known as a stabilizing brace or an arm brace.
The crucial distinction lies in the type of relief sought, a nationwide injunction versus a more limited injunction relief for specific members, companies, and their customers. The looming date of October 16th carries significant weight as it marks the Supreme Court's ultimate decision on whether to grant the ATF the relief they seek. This decision will have broad ramifications impacting not only the Vanderstock case, but also other pending lawsuits against the ATF. These include challenges to the frames and receivers rule, the pistol brace rule, and other cases like the force reset trigger case.
As most of you already know, we've been engaged in litigation against the DOJ and ATF over our FRT-15 forced reset trigger.
Your right to own a gun can also be restricted.
Bump stocks, arm braces, 80% receivers, and now they're claiming forced reset triggers or machine guns.
The Vanderstock lawsuit serves as a pivotal moment in the ongoing battle over Second Amendment rights and the scope of the ATF's regulatory authority. The outcome will not only shape the trajectory of this specific case, but will also influence the course of similar legal battles. For those invested in armed rights advocacy, staying informed and engaged with these legal developments is crucial. As a side note, the mention of the Judge Bonita shirt is a personal touch, offering viewers the opportunity to access merchandise related to the case and potentially show their support or interest in the legal proceedings. Overall, this update serves as a reminder of the intricate legal landscape surrounding Second Amendment issues and the collective efforts of individuals and organizations in advocating for their rights. Well guys, that does it for this video. See you next time, and bye for now.